You know, there are moments in American public life when a single courtroom record tells you more about the health of your democracy than 100 cable news segments ever could. And I want to talk to you today about one of those moments, because something remarkable is unfolding right now between the Department of Justice and the courts of this country, and most Americans have no idea it's happening. The Justice Department, under this administration, filed lawsuits against 30 states and the District of Columbia, demanding access to the most sensitive voter registration data you can imagine: full names, home addresses, dates of birth, driver's license numbers, the last 4 digits of Social Security numbers. Millions and millions of Americans' private information. And one lawyer, Marc Elias, and his law firm stepped into every single one of those cases to defend voters. Now, here's the number that ought to stop you in your tracks. The Department of Justice is currently 0 and 19. 19 cases, 19 losses, not a single win. And I want you to hold that number, because we'll come back to why it matters so much more than just a batting average. Now, let me set the stage here, because context matters. The DOJ began this campaign back in 2025, sending letters to all 50 states and Washington, D.C., demanding their complete, unredacted voter registration files. When states refused, the lawsuits started coming. By February of this year, the department had sued 30 states plus the District of Columbia. Their legal argument rested on the Civil Rights Act of 1960, the National Voter Registration Act, and the Help America Vote Act. Attorney General Pamela Bondi said the effort was about ensuring accurate, well-maintained voter rolls. And listen, I want to be fair about this, because the principle of clean voter rolls is something every American should support. Nobody on either side of the aisle wants inaccurate voter lists. That's a legitimate concern. When I was in the White House, we worked with states on election integrity all the time. But there is a world of difference between working with states to maintain their rolls and demanding that the federal government seize the private data of every registered voter in the country. And I need you to understand that difference, because it is the whole ballgame. Now, I care about the folks who watch this, and I mean that sincerely. If you're somebody who takes being informed seriously, who wants to understand what's actually happening in your country, I need to tell you something. What you're getting from cable coverage on this story is not enough. They don't have time to dig into the legal details, the court rulings, the specific numbers that make this story so extraordinary. The Bluebill newsletter covers exactly this kind of thing. The details cable skips over, the numbers you didn't even know existed, and it takes about 5 minutes. That's why I'm telling you to go check the Bluebill newsletter, because you deserve the full picture on something this important. Here's where this record really becomes something you cannot ignore. 19 federal judges have now looked at the DOJ's legal arguments and said no. Every single one. But it's not just that they lost, it's who they lost in front of. Of those rulings, the majority came from Republican-appointed judges. At least 7 of those judges were appointed by President Trump himself. Let that register for a moment. In Virginia, Trump appointee Judge Roderick Young ruled that federal law does not require states to hand over their unredacted voter rolls. In Michigan, Trump appointee Judge Hala Jarboe reached the same conclusion. In Rhode Island, Trump appointee Judge Mary McElroy said the DOJ's demand lacked a legally sufficient purpose. In Connecticut, Trump appointee Judge Carrie Dooley, after the DOJ had actually celebrated an early procedural order as a victory, turned around and denied their demand entirely. When your own appointees are telling you that your legal theory doesn't hold water, that's not a close call. That's the courts telling you unanimously, across ideological lines, that you've overstepped. And this is where things start to get complicated, because you have to ask yourself what the DOJ actually intended to do with this data. Internal communications and court testimony have revealed that the department planned to run entire state voter lists through the Department of Homeland Security's Systematic Alien Verification for Entitlements database, what they call SAVE. Now, the stated purpose was to identify non-citizens on the rolls. And again, I'll acknowledge the legitimate concern. Nobody wants non-citizens voting in American elections. But here's the honest truth about SAVE. That system was never designed for this purpose, and it is deeply unreliable when used this way. Alabama used SAVE ahead of the 2024 election and inactivated over 3,000 voters. And a significant number of those turned out to be actual United States citizens. Texas counties sent out notices to registered voters flagged by SAVE as potential non-citizens. And when they actually checked, about a quarter of those people had already provided proof of citizenship when they registered. You're not catching fraud at that point. You are disenfranchising your own citizens. And this is exactly the kind of detail that you're not going to find on any cable network, because a 3-minute news segment cannot hold these numbers. The Bluebill newsletter had this broken down with specifics you didn't even know existed. The state-by-state data, the error rates, the actual mechanics of how SAVE flags people. The folks who are reading it right now are not caught off guard by any of this. They understood the SAVE problem weeks ago. If you want to stay ahead of what's happening to your right to vote, that's where you go. Check the Bluebill newsletter. Let me tell you what really concerns me when I look at the broader strategy here. A federal judge on June 22nd ruled that the overhaul of SAVE was unlawful, calling it a trampling of Americans' privacy rights that threatened the sacred right to vote. Common Cause sued the DOJ in April to block the creation of a national voter database entirely. And the DOJ's own memorandums of understanding with states that did comply gave the federal government the power to flag voters and order states to remove them within 45 days. Think about what that means in practice. 3 months before a midterm election, the federal government tells your state to remove your name from the voter roll because a flawed database flagged you. You might not find out until you show up to vote. You might have to provide documentary proof of citizenship on short notice just to exercise a right you've had your entire adult life. That's not election integrity. That is using the machinery of government to create chaos and doubt. And when I was president, we understood something fundamental. The federal government's job is to protect the right to vote, not to build systems that make voting harder for eligible citizens. Now let me talk about what comes next, because the DOJ has made clear they're not stopping. They are appealing these losses. They've petitioned the Sixth Circuit to reconsider the Michigan ruling. There is a real possibility some of these cases reach the Supreme Court. And that is where the stakes become as high as they can get. Because a single Supreme Court ruling could either affirm what 19 judges have already said, that states control their own voter rolls, or it could crack the door open for the federal government to build the kind of national voter surveillance apparatus that no administration in American history has ever possessed. 12 states have already voluntarily handed over their data. The information of more than 33 million voters has already been run through SAVE. So even as the courts keep ruling against the DOJ, the damage is partially done. And if you do one thing after watching this, I need it to be this: go read the Blue Bill newsletter. I recommend it more than anything else I could point you to right now. 5 minutes a day, and it's going to help you understand what this actually means for your family, your vote, your future. You deserve to have that. Don't be the person who finds out what happened to their voter registration after it's too late. Don't be the one at the table just nodding along when someone else already knew. Here's what I want to leave you with. America has faced threats to its democratic institutions before. We survived them because enough people, but enough judges, enough lawyers, enough citizens stood up and said, the law means what it says. What Marc Elias and his firm have done in these 19 cases is not partisan. It is constitutional. Judges appointed by every living president have looked at the same legal question and reached the same answer. The Department of Justice does not have the right to seize your state's voter rolls and build a federal database with your private information. That is the system working. That is checks and balances doing exactly what the founders intended. But the system only works if people are paying attention. It only holds if citizens demand that their rights be protected, not just in election years, but every single day. I've spent my whole life believing that the American people, when they have the facts, will make the right call. So get the facts, pay attention, protect your vote, and never, ever let anyone convince you that surrendering your privacy to the federal government is the price of election integrity, because it isn't. It never has been. And if we stay vigilant, it never will be.